Criminality. My area of research is state crime, and I'm going to be chairing this session. It's my great pleasure to introduce Lisa Hajar, who's our speaker today. Lisa's going to be talking on the Palestinian struggles for justice and accountability, and the things she'll be talking about will clearly be flowing on from some of the discussions this morning around the question of international law. By way of background, Lisa is a professor of sociology at the University of California, Santa Barbara, and currently holds the Edward Said Chair of American Studies at the American University of Beirut, which she just told me she recently got off a plane from Beirut, so hopefully that might make a big impact on your capacity to talk. She is the author of Caught in Conflict, the Israeli Military Court System in the West Bank and Gaza, published in 2005, and more recently Torture, A Sociology of Violence and Human Rights, published in 2013. She's currently working on a book about anti-torture lawyering in the US war on terror. So I'd like you all to welcome Lisa and listen to what she has to say.
Well, I want to thank the organizers for inviting me. My first trip to Australia, hopefully not my last. You guys have weird plugs. And I hope I'll be able to, having gotten off the plane, I'll be able to stay on the train of thought with a bit of jet lag. So what I'm really going to be talking about today, as Michael mentioned, is struggles for justice, but around the question of what good is international law. And, you know, we asked the question, and I want to say that I hope that my comments today, I think, will flow from and be, in a sense, a dialogue with both of the panels this morning, as well as I see the rest of the day, you have several panels on resistance strategies and on BDS as well. Now, the question of what good is international law is not just a rhetorical question. I mean, that's a very earnest, ardent debate with intelligent people coming down in very different kinds of ways about what international law can do in Israeli-Palestinian conflict. And I'm hoping today to give you a kind of sociologist's understanding of a bit of the history and politics of international law. And just to be clear in terms of what we are talking about, I won't reiterate what Ben Saul had said, but just to think about the international law that applies in this context is human rights law, of course, but first and foremost is international humanitarian law, primarily the Geneva Conventions, and that is the main body of the laws of war. And Israel-Palestine is in an ongoing state of war. And so debates about how to understand, interpret, and enforce international humanitarian law are perhaps nowhere more robust than in the context of Israel-Palestine. So, what is international law? Before we think about what good it is, one of the things about international law, and we're really thinking about law as it exists in the post-World War II era. And there are a number of changes since then, but really both the Geneva Conventions of '49, the later additional protocols, and the whole creation of human rights are post-World War II phenomena. And so what these developments in international law did, first and foremost, is to regulate what states can do. And in a sense, that is the primary purpose of states. So it is laws that are made by states and largely for states, and particularly that's true of humanitarian law, because it's about what states can or cannot do in the context of armed conflict. One of the problems and one of the debates about what good is international law has been the ongoing paradox, which is the creation of international law, legal norms and rules, but a lack of international law enforcement mechanisms. Now this has started changing in the post-Cold War era, as I will mention, but really, we continue to have a lack of international enforcement mechanisms. So to some extent, international law, what international law is, oftentimes is defined through a combination of state practices, what states do, how states interpret their obligations under international law, and whether those interpretations develop into an international consensus, and the question of international consensus, how the international community interprets these rules and obligations and norms. But one thing that what good international law does is that it legitimizes actions and aspirations. And so for that reason, international law itself has been a terrain of the conflict, of the Israeli-Palestinian conflict, with both Israeli officials, the Israeli state, and supporters of Palestinian rights, both engaging in interpretive and other kinds of uses of international law to legitimize what they have done, what they aspire to, what they are doing, and so on. So that's one of the key functions, I think. Now, one of the things we could say about international law and the Israeli-Palestinian conflict is nowhere in the world, and maybe perhaps now in the context of the U.S. war on terror, and I will link up to that in a few moments, but nowhere have the debates about how to interpret international, and specifically international humanitarian law, been more intense than in the context of Israel-Palestine. And interpretations that emanate out of this context have had effects on global trends of varying sorts, which I will touch upon. So just to think, to give a very brief history, like one very crucial thing about the sort of debates about international law, in the immediate aftermath, when Israel occupied the West Bank and Gaza in 1967, the Israeli government operationalized a kind of preconceived idea about what laws would bear upon Israel's control of the West Bank and Gaza. This preconception had been developed in the early 1960s, and essentially it was the argument that because the West Bank, neither the West Bank nor Gaza were sovereign to the territories displaced in the war, Egypt and Jordan, that therefore, if one were to interpret the Fourth Geneva Convention of 1949, which applies to militarily occupied territories, the official Israeli position was that these territories are not occupied, but rather they are administered. And that was that position never gained international support. I mean, it defied international consensus, and it never gained international support. But it was extremely important for two reasons. One, this kind of interpretation of the law constituted the cornerstone of Israeli policies, and the ability, not necessarily endorsed internationally, but the ability to argue that what Israel was doing in the West Bank and Gaza was lawful. So things that would be contrary to what the Fourth Geneva Convention requires, no deportations, no collective punishments, et cetera, all of those things could be argued as somehow lawful because of the way in which Israel interpreted the inapplicability on a de jure basis of the Fourth Geneva Convention. But it was also important in another way, in terms of the kinds of constituencies, first and foremost, Jewish Israeli citizens, but also others in the international community. When Israeli officials went to great lengths to articulate very sophisticated arguments about the law itself, about, we love the Geneva Conventions, they just don't apply in this context, et cetera, et cetera. I mean, so different ways of interpreting things had a very important legitimizing function and an ability for Israel to project what it was doing as somehow within the bounds of law. Israel argued that it was not bound on a de jure basis to the Fourth Geneva Convention, but abided by its humanitarian principles on a de facto kind of basis. So for about a decade, in a sense, that no one else was really arguing against that point. And so many of the policies that were instituted in that time had this kind of effect. But, if one were to look, hard at the arguments themselves and at the practices that went on in the West Bank and Gaza, one can see that they do violate both human rights law and humanitarian law. And this would have included collective punishments, such as house demolitions, the confiscation of Palestinian land, and the settlement of citizens of the state into territories captured in war, deportations from the occupied territories, the use of military courts, and so on. Now, up until really, we could say into the 1990s, the way in which Israel governed Palestinians in the West Bank and Gaza, including the military courts, including the ability of Palestinians to petition the High Court of Justice, not often or very, very rarely winning, but it was in a sense a law enforcement model. It was the way in which Israel governed Palestinians was by the use of law, development of military orders, which, largely, as Amira very elaborately and accurately described in terms of criminalizing vast arrays of behavior. So the law enforcement model was, which is contrasted to a war model. That's where I'm sort of positioning these things. The law enforcement model was one where, the expectation for Palestinians was to abide quiescently by the military occupation, under the military occupation, and that there would be some kind of a settlement of the conflict, excluding the PLO, which is regarded as a terrorist organization. It would be, the vision was somehow negotiated among the existing states. Now, Israel, in a sense, this law enforcement model was important in projecting the arguments by the Israeli government and its supporters that the occupation was benign. And in the fact that Palestinians were able to go and petition the High Court of Justice was one manifestation of this ostensible benignness. And that right was established in 1968 by the same individual, Meir Shamgar, who had been the key architect of the argument the previous year when he was the military advocate general that the territories were administered and not occupied. Now, one of the key issues that I think is relevant because of the scope and scale of it is the issue of torture. Because of the law enforcement model being exercised by a military administration over foreign, civilians and essentially hostile civilians, was the idea that you can't have normal policing. I mean, the soldiers were to function in a policing capacity, and so without normal policing, the need for confessions, was probably the only way to gather evidence in order to prosecute people, in order to convict people, and then imprison people. And that, the arrest, interrogation, prosecution, and conviction were a major element of Israel's control strategies. And so since at least 1970, probably 1969, Palestinians who were interrogated alleged torture, but for a long time, the Israeli government officially denied those allegations, said that those were just false claims by enemies of the state, untrue, etc. However, in 1987, something very significant happens, and this becomes a new development in which I would refer to as, and I will explain my meaning in a moment, Israel's trajectory of state lawfare. And by state lawfare, we can refer to that also as the original and not internationally accepted interpretations of the Geneva Conventions, is the way in which a state interprets and uses the law in order to legalize what it wishes to do and to project what it's doing as lawful. Lawfare, as alternative to state lawfare, I would argue, is the ways in which people criticize the state and use the law to challenge state policy. So I use these two concepts, state lawfare and lawfare. So in 1987, one very important development in Israeli state lawfare occurred for reasons unconnected to specifically to Palestinians. There was the establishment of an official commission, an Israeli commission of inquiry, to look into possible illegal behavior by the General Security Services, or the Shin Bet. This was the Landau Commission. And the reasons had to do with the allegations that the Shin Bet had tortured a Circassian military officer, and that there was not allegations, it was evidence that they had extrajudicially executed 3 Palestinian bus hijackers from Gaza. But in the process, the Landau Commission basically sort of contradicted the 2 decades of claims by the Israeli state that torture had not been used, and said yes, as a matter of fact, they didn't refer to it as torture, the Shin Bet had in fact used both physically and psychologically violent interrogation tactics. But they had done so in order to combat the scourge of hostile terrorist activities. And so therefore they should not be criticized for that behavior, because that behavior, those practices are necessary to keep Israel and its citizens safe. But the bad thing was that they had lied to military judges when those confessions were contested. And so what the Landau Commission recommended and the state accepted was that the state would endorse the use of so-called moderate physical pressure, the euphemization for torture. And so in that regard, in late November of 1987, Israel became the first state in the world not to use torture. Most states, the majority of states, use torture, but to legalize, to officially legalize practices that would be regarded as torture. And as it happened, it coincided with the start of the First Intifada, where sort of the law enforcement model sort of amps up into a much more intensive situation where in order to put down the First Intifada, Israel had the highest per capita imprisonment rate in the world at that time during the First Intifada. Of course, my country, the United States, now holds that position. And I doubt that anybody can come close for the foreseeable future. So we can just say that in that sense, the legalization of torture was a prominent feature of what was going on in Israel's control strategies during the First Intifada. Now, I'll come back in a moment to the challenges against that, but let me sort of shift over to Palestinian politics. You know, Palestinians had often been very cynical about international law, certainly up through the early 1970s, as Michelle had mentioned, UN resolutions that were unenforced. The Palestinian nationalist movement that emerges really in the 1960s emerges, with a sort of mandate, like other sort of struggles for, national liberation, largely as an armed struggle movement. And it's only really in the 1970s when you start getting sort of West Bank and Gaza Palestinians starting to really mobilize themselves, realizing that there's not going to be, help is not coming from the PLO in Lebanon or from the Arab, certainly not from the Arab regimes. And so the kinds of, one of the key developments in the, in the late 1970s, and I put this in a global context, was, human rights law, international human rights law, really starts to be, take off in terms of being developed. It's frozen with the Cold War, the Genocide Convention, the Universal Declaration of Genocide Convention of 48, and then there's nothing until the 1960s. And it's in the 1960s, after the waves of decolonization, when you have a totally different composition of the United Nations, that you begin to have the motivations to then draft and promulgate and pass what come to be the main bodies of human rights law: Convention Against Racial Discrimination, against discrimination against women, the conventions on the two Bill of Rights conventions, and so on. And so, but it was still, up until the maybe mid-1970s, human rights was largely the interest of, political philosophers and international law professors. It wasn't, really a sort of widely embraced phenomenon. And it was, however, in the 1970s, in context of conflict, in contexts where people were living under repressive and unrepresentative states, that people began, sort of civil society turns to international human rights law. In Latin America, where military juntas had displaced democratically elected governments, in South Africa, where the anti-apartheid struggle and state repression against it were in full force, and also in the West Bank and Gaza, as Israel's occupation policies and practices were becoming increasingly harsh and repressive. And in 1979, again, Michelle had mentioned, the first human rights organization in the West Bank and actually in the Middle East, which was then called Law in the Service of Man, subsequently renamed Al-Haq, was established. And it did so in order to, in a sense, the original establishment of Al-Haq, and it was then sort of inspired the creation of the Gaza Center for Human Rights, which was eventually taken over by the PA and then renamed Palestinian Center for Human Rights, etc. There's a history here. But their original intention, and what they did very successfully, was to really start engaging with the kinds of Israeli international law arguments, actually sort of writing back against the claims that the Geneva Conventions don't apply, or that the various practices are perfectly compatible with Israel's duties as then the administrator of the territories, and so on. And what you had was the development very quickly, sort of adopting it and being one of the probably leading, places in the world where the development and use of human rights methodology, monitoring, reporting, and then transnational advocacy really took place, sort of grow up out of Palestine, out of the West Bank in particular. And in a sense, the kind of products that were being produced through Al-Haq and the discourse was to internationalize the conflict in new ways. I mean, to really present, like writing back and pushing back against Israeli interpretations of international law and garner with, sort of great intellectual aplomb, high quality, research, etc., and law-based analysis. And so it really, deepened the production of knowledge about the occupation and the conflict itself. And when the First Intifada started in 1987, this was the heyday for human rights organizations. A number of other ones had been established in the 1980s. Why did that matter? In a sense, international human rights law and humanitarian law, and those two were wedded much more tightly than in other contexts because of the occupation, was where you had a lot of people, very skilled and talented, both Palestinians, foreigners, as well as Israelis. I mean, B'Tselem, was established in 1988, I believe, who are able to blend an international law analysis with a very deep, empirically based, studies of the conditions on the ground. And so the First Intifada was, commanded global attention. I mean, there were media all over the place for years. And in a sense, it was the heyday for human rights activists and organizations, because when journalists would come, they want to get, sort of fact-based analysis with, something that they could report on. And, there was a lot of sophistication. We can find a lot of criticisms as well, but they really had their heyday. And again, as Amira had mentioned, the whole this whole chapter of the, could human rights become, or international law, be a basis for ending the Intifada and the occupation and producing some kind of state peaceful resolution. Well, international law was completely sidelined by the Oslo process, not least because the United States took command of that process, and the United States has a long and quite pronounced hostility to international law, with the exception of the slightly less, during the Carter years. So the whole Oslo process was premised on political agreements to which international law was explicitly excluded, in a sense. So on the one hand, that becomes, one can then think about what happens as a result of that. The Oslo process has been an abominable failure. But because of the Oslo process and the way it was constituted, what you get is new levels of human rights and international law, humanitarian law violations. In the 1990s, you have a cycle of suicide bombings by, in the 1990s, it was only Hamas and Islamic Jihad who were in part, engaging in suicide bombings in retaliation for Israeli targeted killings. So it's a cycle. But it was also a means of undermining the legitimacy of the Oslo process itself by putting, pressure in that particular kind of a way. So the targeted killing, suicide bombing phenomenon was one that still characterizes discourse. I mean, we still are thinking about the conflict there in terms of suicide bombings, et cetera. But it was very much, a kind of the suicide bombing, targeted killing track ran parallel to the Oslo negotiation track, and neither of them produced much. Now, let me just say something about targeted killing. Israel was engaged. I mean, of course, Israel is engaged in assassination operations, for decades outside of the territories. But in the territories, the undercover units began engaging in targeted killing operations during the First Intifada. But like torture, it was staunchly denied, absolutely denied, despite the fact that there were lots of documentation about the fact that Israeli special forces, dressed up as Arabs or snipers, were shooting specific targets. So the targeted killing was unacknowledged. Meanwhile, let's come back to torture, my favorite topic. The issue of torture was being litigated in the High Court of Justice throughout the 1990s. And as a result of the litigation that was ongoing, it was both Palestinian and Israeli groups, but only Israeli citizens can litigate in the High Court against the state. And it was, in a sense, a real, sort of using the terrain of the High Court itself to ask not only what is legal in the context of the West Bank and Gaza, but what is legal internationally. Because the High Court of Justice pitches itself and is perceived both in Israel and among supporters of Israel as a highly sophisticated court, renowned for engaging in some of the most complicated issues. And so the question of whether or not the High Court of Justice of Israel would find the practices, the legalization of minor physical pressure to actually be acceptable or not would have had international ramifications. And as it turned out, the High Court's decision in 1999 basically said, routine use of moderate physical pressure, not acknowledging it was torture, is unacceptable. However, it left open special measures for special circumstances, such as the so-called ticking bomb scenario. But it was, in a sense, in that decision, people looked at it at the time as one of the very rare instances in which the Israeli High Court of Justice had not accepted the state's state lawfare arguments and pushed back on it. Now, 1999 then comes, let's think sort of in parallel time, what good is international law in the post-Cold War era? Of course, the Cold War ends in 1990, and since 1990, international law has had another significant transformation. And that is, really the expansion of the ability to use rather than merely cite the law. And in particular, the development from its moribund status since the closing of the Nuremberg and Tokyo type tribunals to actually use international criminal law, to develop international criminal law, which began, of course, with the establishment of the UN ad hoc tribunals for the former Yugoslavia and Rwanda in 1993 and 94, respectively, and then subsequently the negotiations that took place in Rome in 1998 to establish an international criminal court, which comes into being in July 1, 2002. And also, a very significant thing for the Israeli-Palestinian conflict is the sort of the development or the resurrection and reinvention of the concept or the doctrine of universal jurisdiction. And the key pivotal case there, of course, was the arrest of former Chilean dictator Augusto Pinochet on a warrant from Spain. Spain requested his extradition, and it was in the process of the British legal system determining whether or not Pinochet, as a former head of state who was charged with torture and genocide, the charging judge attempted to rewrite the law of genocide to include political mass murder, but didn't work. But the British High Court did, in fact, recognize that that there is no sovereign immunity for torture, and that Pinochet, former head of state, was in fact, indictable and extraditable. And for political reasons, the British government, let him go back to Chile. That's a second story. I'm happy to talk about it. But as a result of the Pinochet precedent, a number of countries, foremost in Europe, primarily in Europe, revised their own domestic laws in order to allow universal jurisdiction cases. And just to explain what universal jurisdiction, for those who don't know it, it's an international criminal doctrine that basically permits the prosecution of individuals in national courts, foreign nationals in courts of another country, even where the crime didn't occur, on the grounds that are the principle of universal jurisdiction is that some crimes are so heinous that they menace international peace and security, and therefore all countries have an interest in prosecuting the perpetrators, who are enemies of all mankind, hostis humani generis. And so with this, Pinochet precedent, a number of European countries, either created or expanded their universal jurisdiction laws, including, one of the sort of first out of the gate was Belgium. And Belgium opened its courts to allow for foreign victims to bring suits against foreigners. And so because of the lack of enforcement mechanisms, the lack of avenues of justice, victims from many countries, including Palestinians, brought cases in Belgium, including a case against Ariel Sharon, brought on behalf of the Palestinian victims of the massacres in Lebanon at Sabra Shatila. There were cases attempted to be brought against U.S. officials for violations in the first Gulf War, et cetera, et cetera. So what you see then are the possibilities of, sort of international law gets developed through these kind of practice-based methods, but there's always the politics, right? So you get immediate pushback, politically, diplomatic pushback, and Israel and the United States have been sort of the leading governments to push back against universal jurisdiction laws to the extent that they would be used against citizens or agents of their own state. But also in the 1990s, in terms of like the development, the kind of possibilities of expanding the use of international law, was the creation of a position of the UN Special Rapporteur for Human Rights in the Palestinian territories. So the UN also becomes a kind of a terrain where international law has moved to a higher and more sophisticated level in the 1990s, and it also, is as always, a terrain itself of fighting, and the UN Security Council being one in which the United States has routinely used its veto power to oppose any kinds of international law-based initiatives that would pursue accountability through a UN mechanism for Israeli violations of humanitarian law. Now, 2000, the Second Intifada starts. It starts as a result of the breakdown of the Oslo process. One of the things that is critical to understand what's going on now, and again, it has very global ramifications, was if Israel in 1967 had claimed that the Palestinian territories were not occupied, what they claimed after 1993 was that they were no longer occupied. So they went from not occupied to no longer occupied, at least those areas A, because Israeli forces had been withdrawn from Palestinian population centers. So that becomes very significant when the Second Intifada starts, because Israel could then, use the argument that Israel was no longer occupying these areas to justify the use of a war model. And from the very outset of the Second Intifada in September of 2000, Israel combats what begins as mainly, mass protests with heavy weaponry. Now, as far as international law interpretations would go, the territories are of course still occupied. They're all still occupied. Gaza is occupied, West Bank is occupied. We can discuss that. But Israel claims that they're not, but that's one of those debates we have. The thing that would, the argument would be that because Israel was no longer occupied, it was illegally permissible to sort of wage war on what was referred to as a foreign entity, being the West Bank and Gaza. In November of 2000, Israel once again beats everybody in the world to legalize targeted killing. So they've been engaged in targeted killing since 1988, but in a strike in November of 2000, for the first time the Israeli state officially acknowledges, yes, we killed this person, and here's why. And their rationale for the legality of targeted killing, which goes directly to interpretations of international humanitarian law, is that that these people are engaged in hostilities against Israel. They pose an imminent threat. Arrest is impossible. This attack, the attacks are crucial for national security. These kinds of attacks, and so it was this particular. Sort of argument that then, targeted killing, now being officially acknowledged, really starts stepping up, including officials of the Palestinian Authority. And so I would just mention, I'd be happy to entertain comments in the question and answer session. Clearly, Israel's earlier, not the 1999 Supreme Court case, influenced the U.S. Bush administration's legalization of torture, and very significantly, if one looks at the few things that have leaked out about the U.S. targeted killing policy, extracted after years of litigation. It's the legal opinion about the legality of targeted killing is very heavily based on the Israeli model. And in fact, the Israeli targeted killing, the legality of targeted killing was taken up as a case in the High Court of Justice. It was brought by the the Public Committee Against Torture in Israel and Law, challenging the legality of targeted killing. And the Israeli government made the argument that this has to be considered legal. Imminence cannot be narrowly. We have to regard imminent threat as in a much broader sense, partaking in hostilities in a much broader way. So really challenging some of the fundaments of international humanitarian law. And ultimately, the High Court decision in 2006, which was written by the former Chief Justice Hajar, who came out of retirement to do this one, basically because he has a very international reputation as a sophisticated thinker, basically said that targeted killing is not illegal. It may sometimes be illegal if the use of force is disproportionate or there's not a militarily necessary reason, but essentially the High Court gave its imprimatur to the principle that targeted killing could be legal. And it was, in that regard, it becomes very influential for the United States. Now, Israel, among the targeted killing operations that Israel engaged in, the most infamous occurred in July 2002, when F-16s dropped a one-ton bomb on an apartment building in the Garage neighborhood of Gaza in order to kill someone named Shahate, who was one of the commanders of the Hamas armed wing, but it killed 15 people, injured 150, et cetera, et cetera. There were some domestic, sort of investigations, but Israel basically said that this was a legitimate operation. Unfortunately, due to some problems in our intelligence, we didn't realize there were innocent civilians living in the hideout, which was in an apartment building. But there were a number of universal jurisdiction initiatives brought, first actually in the United States, because the United States also has kind of universal jurisdiction, and then attempts to pursue Israeli individual officials responsible for the Shahada bombing in Britain, in Spain, in New Zealand. I'm not sure if Australia was one of them, and always it was political pressure. There's never been a court decision by any foreign government that Israel's approach to position on targeted killing is lawful, but rather the kind of judicial discretion not to pursue criminal accountability. But it remains a live issue. And just in my last few moments, I would just say, we can think about what's happened in Gaza over the last, say, decade now, I guess. That Gaza has really been a laboratory for not only for military tactics and techniques and strategies, but also for Israel's state lawfare arguments about what is and isn't lawful in the context of an armed conflict of that sort. And I would just recommend to you Eyal Weitzman's very interesting book called The Least of All Possible Evils. He does very interesting, sort of looking at the mechanics of, the way in which Israel has essentially engaged in what we would call the macabre algebra of proportionality in terms of who can be bombed, when bombing can occur, etc. So it's become a very algebraic operation with military lawyers and targeters, etc., being able to make claims, whether they're accepted or not, about the legality of international law. So I would say that, one of the key, there was, of course, Operation Cast Lead in 2009, which led to the Goldstone Commission, which led the Israeli government to condemn this thing called lawfare, which had sort of been operating for a while, to characterize lawfare as a strategic threat. Operation Pillar of Defense in 2012. But Operation Protective Edge in 2014 might have been a game changer because there's so much material and forensic evidence about the targeting that attacked, clearly civilian areas where there would be no military objects, even if aside from the fact that militarily attacking occupied territories is prima facie a war crime. But we can say that we're seeing how international law remains sort of a very open terrain, and it's important for all of us to be, sort of comfortable with international law concepts. I mean, I always tell my undergraduates who I teach this stuff to, no offense, law is not rocket science. Everybody can figure it out. But I would just say that the least
Just make it up.
exactly. But you can make it up with footnotes in a good way. So we can just see the most recent developments that the Palestinian Authority's accession to the International Criminal Court, which took, sort of went into effect in April 1st, has caused the Israeli government to be anxious about the possibility of what they refer to as a diplomatic intifada. So international law must have some force if it's so, if it causes this kinds of engagements and anxieties. And so I don't have an answer to what is international law, but I always try to stress the fact that it is a crucial, important, and very complex part of the conflict that opens up to a lot of extraordinarily interesting questions and very important developments in the lives of Palestinians and Israelis.
Thanks very much for that, Lisa. It was an extremely sort of rich presentation. I'm sure raised a whole lot of questions. We started 15 minutes late. I'm reluctant to cut into future sessions, but I also don't want to fail the discussion either. So I'll ask for groups of 3 questions, and then we'll see how we go after the first round. Jess? Jess? Amira and Mike.
Thanks very much, Lisa. It was a great presentation, and I wanted to ask you about the way that you framed the occupied Palestinian territories as, in a sense, a laboratory, both for Israel's attempts to transform the laws of war in a more permissive direction, which we've seen very clearly in the case of Gaza, and the way that they've attempted to define and redefine, in particular, the category of the human shield. But you also talked about the territories as a laboratory for human rights activism and fact-finding around the time of the First Intifada. And it seems to me that at the moment we can observe another kind of laboratory-type move coming out of Israel in particular in relation to human rights, which is the push for standards for human rights fact-finding. And this has been pushed particularly by NGO Monitor, which describes itself as monitoring NGOs that use their, supposedly impartial human rights arena to criticise Israel. But one of the things that NGO Monitor does is constantly puts out reports attacking NGOs that criticise Israel for its military conduct. And this seems to be being taken up in human rights world more broadly, where this push for standards for professionalising the human rights world is being taken on by NGOs. And I just wondered, well, in a certain sense, I love your, international law is not rocket science. When a struggle like the Palestinian struggle does migrate into a territory of international law, how much can you really say everyone needs to familiarise themselves with international law concepts, and how much does this lead things in a professionalising direction that tend to disempower Palestinians from actually adequately participating and leading their own liberation struggle?
What advice would you give now to PA in the West Bank, Hamas in Gaza, how to use international law in order to promote the struggle? And would it be the same advice or not?
Yes, so I think you probably ended it about the International Criminal Court, the ICC, and its prospective possible role in holding Israeli war criminals to account. And
I didn't understand.
that the ICC might hold Israeli war criminals to account. And there's been a kind of a cynical response to that by some on the left who say that the ICC isn't ever going to hold certain countries or nations in power because it's basically political, and that's why everyone's ever prosecuted has been the macro. And I don't know much about the structure of the ICC or kind of who pays its skills or whatever, but I wondered if you could speak about whether or not the ICC actually ever would hold Israel accountable.
These are great questions. So to Jess first, Gaza, yes, the Gaza the Gaza as a laboratory. I think it links up also with your question about, or the question about Michael's question. It's, you know, the issues of how like militaries themselves are, you know, engaging in certain kinds of conflicts. I mean, the use of drone technology, the sort of the, you know, sort of arguments about human shields, like what constitutes a human shield, and so on and so forth. Those are things where, you know, militaries, you know, are going to be taking lessons from, you know, the arguments that the Israeli military is making. And of course, the international law division is, you know, quite sophisticated, certainly the United States and other countries where, you know, in that regard, it's one laboratory of like the so-called state practice that sort of constitutes what is the current standards of international humanitarian law. So there's, you know, some degree of that's like laboratorial. As far as, you know, but it is also in a sense perhaps a laboratory around questions of how Palestinians may take advantage of the current climate and opportunities in the world, you know, possibly the ICC, and I'll come back to Amir's question in a second, but in order to, you know, sort of think about questions of justice, like when, so it's a sort of ex post facto, really looking at a sort of a war crimes, like is there going to be accountability for certain, you know, for example, targeting United Nations facilities, which would be perhaps an easier thing to move through, you know, the system. And so we can see, I mean, we don't know yet what the outcomes will be for those types of things, but it is the question of like people thinking about international law as a response to the devastation of Operation Protected Edge, for example, as one sort of response. I mean, in the sense that they're even pitching an international law violation argument internationally in order to seek political and diplomatic sort of responses. So there's that element. As far as NGO Monitor, and you know, there's also UN Watch and a few other organizations that are absolutely sort of like, they regard lawfare as a terrible thing, right? There's the lawfare, you know, which I think lawfare is an awesome thing, but for the very same reasons they think it's a terrible thing. But yeah, so one of the things that, you know, the NGO Monitor, UN Watch, both aim to discredit people sort of, you know, arguing, you know, from a very clearly Israeli sovereigntist position that Israel has a right to defend itself. Criticisms are either false, you know, because Israel is you know, sort of limits its use of force in the most tailored. I mean, so it's an ideological argument that then gets, you know, sort of linked up to the kind of empirical research that organizations are doing. But I think a crucial thing for us to think about is that the Israeli Knesset, I mean, the Israeli polity, you know, voting polity has moved, and certainly the, you know, elected officials have moved even more right, we're sort of more thoroughly right than they have been for a while. And so, you know, there is the criminalization now of NGOs, human rights groups, to pass information out of the country for the purpose of pursuing accountability against Israelis. And one thing I would just mention is a forthcoming book by Neve Gordon and Nicola Perugini called The Human Right to Dominate. And so that book is actually looking specifically at the way in which Israel has, you know, interpreted its various rights to dominate, to kill, to colonize, to annex, using an international law arguments. It should be out, I think, soon. Amir, you know, one of the things when people invite me to talk about the peace process, I always say I never talk about the solutions. I only talk about the problems. You know, I'm about war. Peace is for somebody else. But the advice I would give to
I didn't mention the word peace.
yeah, no, but this is also the same thing, like to use it in a sort of helpful way. You know, I actually, one of the things that I found striking when I read and, you know, wrote a book, another book I'd recommend, I like to get my friends, you know, books so is Lori Allen has a book called The Rise and Fall of Human Rights, and it's about the politics of cynicism, and particularly around this. And one of the things when I was reading the book, I was literally slack-jawed, but she makes an argument that she actually sort of bolsters it with her evidence, I mean, to some extent, that Hamas actually has a kind of sincere, she juxtaposes sincerity with cynicism, and a kind of a sincere commitment to international law. For example, the right to fight, you know, that would be one way, but also that Hamas had been willing to endorse the PA's accession to the ICC, including, and having said that they would take what came of it, including, some of their individuals being prosecuted for the war crime of shooting, missiles into civilian areas across the border, whereas the Palestinian Authority, has only agreed to it in a rather quite cynical way. And the PA is quite cynical in general. Was they didn't want to do it because the United States, which of course is not a signatory to the ICC, did not want that to happen, and Israel would say that it would break down the peace process. But I think it was events in recent months that basically got the PA to also say, okay, we're going along.
No, but PA stopped it. And then Hamas joined in.
I thought that Hamas was arguing it. Okay, then we're okay.
It was clearly when there was pressure during the war in Gaza, there was pressure and from people in Ramallah and around the Hub and others that.
But was it PA officials?
It was PA. Arikah was the first one signed by Arikah
okay.
with the letter,
I stay
and then it
corrected.
took time. Hamas and Jihad took them time to decide, and at the end, under pressure, they signed.
Okay.
But they were not the first ones. Not at all.
I think that, my sense is that how to use international law. One is don't attack civilians. but the question is, sort of I would say that it's worth going back and looking at the model that the ANC had adopted. We're almost like cycling back to that. Like if you look at the speech by Nelson Mandela, at the Ravonia trial, when he talks about what to strike and what not to strike in the fight for justice. So in some sense, respecting certain principles of international law, and I would say, and I'll leave it to the BDS panel, but the kind of the mobilization of international law norms and rules is a way of pulling legitimacy, right? That's the way in which one can use it. And if coming to the question of Michael about the ICC, it's true, the ICC, I personally am I've always been critical of the ICC because of the way it reinforces and operates in the sort of global, sort of the state-centric system. So powerful states, in a sense, it's not going to operate fairly. It's going to be very much dictated by the politics of the United Nations and the Security Council and powerful states. It's a state-centric institution. I prefer universal jurisdiction. Although universal jurisdiction has not proven itself yet to be, sort of the means by which accountability has been pursued, it's the much more viable option, I think. And even the Council on Europe, since 2003, and more recently, the initiatives of the UN Special Rapporteurs for Counterterrorism and summary executions did a study of targeted killing and have advocated universal jurisdiction as one of the means of pursuing accountability for illegal operations that target and kill civilians. So I wouldn't have much faith in the ICC either. I think it's a move, though. What you see with the PA or when Palestine acceded to the ICC is you see, in a sense, the kind of the curtain comes off of Oz, like the United States, claim. Under Obama, and of course, I'm happy to answer any questions about Obama. But sort of challenging, saying that it's not helpful to invoke international law. So that's kind of a very, American answer to, historically consistent.
I think we'll need to end it there, but I'm sure there's lots of other questions you've asked, Lisa, and maybe you get a chance to do that later on. Could you just join me in thanking her?